Yes.
Lord Lady, I hope not to detain you too long. I want to go back to argument 2 very briefly, if I may, and take you back specifically to, I think it's a passage I've already mentioned in Woodfall, but it's 6054 at page 362 of the authorities bundle.
362.
And could I ask you to read it? But the main factor which determines what kind of periodic tenants should be inferred in the absence of agreement is the period by reference to which the rent is calculated. And that's the...
Sorry, I didn't hear.
Sorry, I'm reading the first line of 6054.
Yeah, I get that. Yeah.
Sorry, and I'd perhaps invite you to read all of that. If not now, then at your leisure.
Yeah.
And the point is this: if one looks at clause 2.1, this agreement is capable of continuing after the end of the minimum term. And one asks oneself, on what basis is it continuing? It's continuing on the basis that the tenant agrees to pay an annual rent. And the clear implication, we say, given all the other things, is that it's an annual periodic tenancy.
Yeah.
I'm grateful for that. In respect, and if one looks at the iterations that I produced in my document, which I will undertake to provide to you electronically, we say in effect iteration 4 is the same as iteration 5. Iteration 5 says expressly what iteration 4 has by implication.
Yeah.
And that's by implication from the rest of the terms of the tenancy agreement.
Yeah.
So far as the argument 3 is concerned, I'm afraid I've got just a little more law for you. I've got 2 further passages from Woodfall. They're very brief passages. It's all about the entry under a void lease.
We're going to need to send them electronically.
Yes, I undertake. We will send electronically.
I mean, everybody who appears, I haven't had a document handed up to me for 3 years.
Right, well, I apologise for...
Can we make sure
Yes,
I get them?
absolutely.
You've got loads of people behind you with
absolutely.
computers.
Yes,
somebody send it to me electronically. I really don't want bits of
If we
paper.
get an email address, we can send it to you forthwith.
Yeah, you send it to my clerk.
All right. It's done. I'm grateful.
Yeah, thank you.
Thank you.
You can read it out. I'm not looking at paper. I can't read paper.
All right, I'm good. It's Woodfall 5005 and 6066. Secondly, if the tenant enters into possession under a void lease, he thereupon becomes tenant from year to year at law upon the terms of the instrument, so far as they are applicable to and make them consistent with the tenancy. Such a tenancy may be determined by the usual notice to quit at the end of the first or any subsequent year, and will determine without any notice to quit at the end of the term mentioned in the instrument. If the tenant does not enter, he will not be liable to an action for not taking possession, nor will an action lie against the landlord for not giving possession at the time appointed for the commencement of the term, but before the lease is executed. That's 5005, 6066. If a man enters under a void lease, he's a tenant at will at common law under the terms of the lease in all other respects except the duration of time, although in equity he may be entitled to consider himself under an enforceable agreement for lease. But even at common law, the court leaned away from a tenancy at will in such circumstances, and consequently when the tenant paid or agreed to pay any of the rent expressed to be reserved, he became a tenant from year to year on the terms of the void lease, so far as applicable to and not inconsistent with a yearly tenancy. Now, that doesn't say anything different than what, but it's an illustration of just that is the standard form as expressed by Lord Templeman and by Lord Justice Lewis, and that is the standard provision. And yes, my Lord, I do make the point that insofar as there is any difference between the prudential, the speeches of the House of Lords in Prudential and the judgments of the Supreme Court in Mexfield, then the latter are obiter.
What's the essential difference between the two? Why in Mexfield do they say it's inconsistent with the language when it was inconsistent with the language in Prudential?
One doesn't know. I mean, it may be a circumstance, it may be an application of the Dirty Dogs Act. One doesn't know in the sense that, a merits-driven decision.
But it's not a merits-driven decision. It's a common law-driven decision. you can see from Lord Clark and Lord Mance that they're very highly motivated by the fact that what is proposed is a periodic tenancy with terms that is inconsistent with Clause 6.
Yes.
And in Prudential, it was exactly the same. It was a periodic tenancy with terms that were inconsistent with the provision about building the road.
Yes.
So what's the difference? I don't get it.
Well, there may be no difference. I mean, it's difficult to explain. But in my submission, there's nothing here. Let me start with that. There's nothing in this agreement which would render, which would cause you to apply any principle applied in Mexfield. Here the parties have agreed it's a 10-year minimum term, but it's terminable upon notice. And if the only, the thing that is void is the term, it's still terminable on notice. And there's nothing inimical about an annual tenancy term, even a 12-month notice period. So that's what we say is clear by implication.
Why couldn't you take out the bit that was objectionable in Mexfield? I mean, in Prudential, you could take out the bit that was objectionable and leave the other terms of a periodic tenancy that were not objectionable effectively in place. And in Mexfield, you could have done the same. You just took out the Clause 6.
Yes, but that would have
You
enabled...
said that's inconsistent with the need for it to be terminable on a month's notice by the landlord, and therefore it's fine.
Yeah.
So I mean that there has to be if there is no distinction. I mean, I haven't read every single word in Mexfield. You obviously have. I guess they must have told us why they thought it was different.
I'm not sure they do. I mean, the point, I suppose, is that Lady Hale's point she makes, the fact that although it's odd that this becomes a 90-year lease by reason of the old common law rule by which an indeterminate term becomes a life tenancy, which is by the Law Property Act converted into a 90-year term. That was, in fact, what the parties had agreed. They stood back and looked. This was if you look at the background to the Mexfield case, it was a mortgage rescue operation where Mrs. Beresford had fallen into arrears. The mortgage, or maybe the mortgage company had gone bust and was taken over by an entity which was there to save Mrs. Beresford from being evicted. And the way to do that was allow them to grant her what was a monthly tenancy with the provisions in Clause 5 and 6. And thereby she had security of tenure in that respect under Clause 6, because she couldn't be turned out by her landlord unless she was effectively in breach of the terms of the lease. And the party intended that it was intended to be a long-term agreement. Now, by the magic of the common law and the Section 1496 of the Law Property Act, that became a 90-year term, which, as Lady Hale says, well, that's not completely it's not completely incomprehensible, given that this was intended to be a long-term relationship to allow Mrs. Beresford to live in what had previously been her home. That's the only thing I can think of by way of background, but there's no express contradiction of what is said in by Lord Templeman in Prudential in any of the judgments in Mexfield, so far as I can see and can remember. It's not. There's no debate on this point, as in Lord Templeman said this at page 145 in our authorities bundle. But we think we can distinguish that in this case because of XYZ grounds. I don't believe there is anything. For Lord Manson or Clark don't refer to Prudential at all.
In this case, just so that I'm absolutely clear about your submission, in cases where there is a specific clause which offends, if one follows the prudential model, say this is a void lease because, for example, of clause 5 or clause 6, we will, the tenant in inverted commas entered into exclusive possession on and has paid rent on a certain basis. Accordingly, it's a yearly tenancy or whatever, periodic tenancy. And therefore you've put the offending clause which was agreed on the shelf.
Yes.
And in this case, you would say which bits go on the shelf?
It's the, we would submit it's the 10-year minimum term, determinable on 12 months notice at any time. I mean, it starts with the entirety of clauses.
So in fact,
Really?
the whole thing.
Well,
Goes
say
on
if
the-
you can, there's nothing wrong with saying, in fact, the parties have agreed 12 months notice instead of 6 months notice. That's not inimical to a yearly period.
So that's the only bit that would be saved out of clause 2.1. I just wanted to
Yes,
have that
I
clear.
entirely understand that. If you're going to blue pencil it, where do you, to what extent do you blue pencil it? But that appears to be. Yeah, I mean, again, if you look at the words of what Lord Templeman as he describes the principle. Tenant entering onto void lease became by virtue of possession on the payment of a yearly rent, a yearly tenancy holding on the terms of the agreement so far as those terms were consistent with the yearly tenancy. So any terms which are inconsistent with the yearly tenancy fall to be disregarded.
And could you explain to me then why that gives no scope for deciding that the agreement is a license? You always have a situation in which you've got something which fails to be a lease for a technical reason, let's call it that, and is treated as a lease as a result of entry and payment of rent. So there's no scope there for that agreement to be a license. Is that because in the Prudential case and in the Maxfield case, what you'd got was something which purported to be a lease, but then had this single flaw?
I think it's, yes, it's the basis is that you have what might otherwise be a lease, but for example, some term which renders the term uncertain. But you take exclusive possession and pay a periodic payment by way of rent. And that, the law derives from that, the yearly periodic tenancy, or the monthly if you were paying rent monthly. And that's, I think it's the exclusive possession which alters the situation. What might, if you get by contract what might otherwise be a lease, but for something which renders it void, and then you enter into possession of the premises, exclusive occupation, and pay a periodic payment pursuant to the terms of that agreement, then you become a yearly periodic tenancy on the terms of that agreement, insofar as they are not incompatible with it being a yearly tenancy.
I mean, the way Lord Templeman describes it is at F to G at page 145. Well, not really in the first bit where he describes the principle, but he describes the submission that will be made against you. It said that when in the present case the tenant entered pursuant to the agreement and paid a yearly rent, he became a tenant from year to year on the terms of the agreement, including clause 6. This submission would make a nonsense of the rule that a grant of an uncertain term does not create a lease, and would make a nonsense of the concept of a tenancy from year to year. Because it's of the essence of a tenancy from year to year that both the landlord and tenant shall be entitled to give notice determining the tenancy.
Yes, my lord, because that offends against the principle that you enter on the terms of the agreement so far as those terms were consistent with the yearly tenancy. What it was said, the submission there, was that in the present case, tenant enter pursuant to the plenty year term, including clause 6. That is the one which offended against the term against certainty. Just trying to find what clause 6 is. Whether it's cited. That's right. Clause 6. It's at 142. Letter G. The only relevant proviso for termination is clause 6. So that's the very clause which was deemed to be offensive.
Yep.
So the submission was, well, you enter and you became a yearly tenant, subject to all the terms of the agreement, even that which is inimical to it being a tenancy at all, and that's the submission which would make a nonsense, and it just makes good the point that at major C, holding of the terms of the agreement as far as terms are consistent with the yearly tenancy, clause 6 was not consistent with it being yearly tenancy, and therefore it was effectively penciled.
I mean, did the Law Commission look at it following Lord Brown Wilkinson's strictures?
I'm afraid I don't know, is the answer. I can find out.
You find out.
It certainly haven't looked at it by the time of Mexfield, because there's no, I don't think there's any mention in fact, if you look at Lady Hale's, I think it's in the last paragraph of Lady Hale's judgment, paragraph 96, she would appear to say no.
Okay.
My lords, I'm slightly longer than I anticipated. I'm very grateful. Those are my submissions.
Thank you very much. Yes, Mr. Bradley Gardner.
My lords, my lady, if it's considered, the court considers it helpful, I was going to first of all take the court chronologically just through a few parts of the leading cases that we haven't yet looked at to fix the nature of the rule that's under consideration, and then to deal, insofar as you wish me to deal with, the three arguments that are arrayed against me by my learned friend. And my learned junior and I have done a certain amount of further work on the observations that my Lord the Master of the Rolls has made on the relationship between Prudential and Mexfield, which I'm happy to deal with off the top now if the court would like me to.
That would be very helpful.
The essential position that one gets to is this. The first thing to look at is the arguments and submissions that were made to the House of Lords in the Prudential case and what the rival contentions were between the parties. And this was a case in which, as you will see if you look at the report of the argument at 141, between letters, sort of starting up just below letter A, the only contention which the House of Lords was there grappling with and asked to consider was the rival position that the agreement in its original form was after all valid as conferring a term certain.
Sorry, I'm not sure where you are.
It's page 141 of the bundle of authorities, just below letter A.
Accordingly.
Accordingly. And this is recording the submission made on behalf of the second to fourth defendants, who were the landlords in that case. And what they were contending for was that the inexorable consequence of invalidity for uncertainty was that instead a valid periodic tenancy arose. And the reason that submission was made was in that case, as you'll remember, a common law notice to quit had been served on the tenant on the premise that they were annual tenants. So in fact, in Prudential, the House of Lords was not being asked to consider the third, and what we term in our skeleton argument, the modern alternative, which is whether this agreement could take effect, absent being shorn of its offensive terms insofar as they were repugnant to a periodic tenancy, if it could take effect as a pure contract. So that's the first observation to make on what was being asked of the House of Lords in Prudential. And in my respectful submission, the way to reconcile the authorities is by reference to the judgment of Lord Neuberger, in which he considers Prudential and considers also what the nature of the so-called rule is that is said that my learned friends rely upon. And one finds that by going to Authorities Bundle, tab 17, page 190, and right at the bottom in italics, which is the section headed Ms. Beresford's alternative case in contract. And Lord Neuberger starts that paragraph by observing that the conclusions they've already reached on the conversion of the tenancy into a 90-year term renders it unnecessary to look at the alternative arguments. But he then says, having heard submissions at 59, I incline fairly strongly, he says, to the view that if Miss Beresford had failed in establishing that she had a subsisting tenancy of the premises, she would nonetheless have defeated Mexfield's claim for possession on the ground that she is entitled to enforce her contractual rights. So, absent the statutory intervention, Lord Neuberger's fairly strong view that he inclines to is that there's no reason to invalidate contractual arrangements which parties are otherwise entirely free to make. He goes on, if the agreement does not create a tenancy for technical reasons, namely because it purports to create an uncertain term, it is hard to see why, as a matter of principle, it should not be capable of taking effect as a contract enforceable between the parties personally, albeit not capable of binding their respective successors, as no interest in land or other proprietary interest would subsist. And then just to add to what my learned friend said this morning, there is in fact a discussion then, very briefly, of both Lace and Chandler and the Prudential case in the following paragraphs. Lord Neuberger records Lord Green's view, and then he goes on to record that the same view had been taken in Prudential. It appears that Lord Templeman treated as void a fetter for an indefinite period on the right of the landlord under a periodic tenancy to serve a notice to quit. So the position that emerges from both of those brief considerations of Lace and Chandler and Prudential is that both of those cases proceeded on the assumption that the parties to those contracts were seeking to create a tenancy. That will become relevant because in my submission, Prudential and Mexfield are to be understood as not in conflict, but as simply an application of the principle that the court needs to find the best fit to give expression to the intentions of the parties. And Lace and Chandler and Prudential would be cases where, leaving aside my point of where the battle lines had been drawn on Prudential and what was properly an issue in the House of Lords, that those two cases are cases in which the parties had clearly endeavoured in the clearest terms to create a right in the nature of a tenancy. Lord Neuberger goes on at paragraph 62 to say, it does not seem to me that the observations of Lord Green, MR, the ones in Lace and Chandler that feed into Prudential, can withstand principled analysis. As Lord Templeman made clear in Street and Mountford, while the parties' rights and obligations are primarily determined by what they have agreed, the legal characterisation of those rights is ultimately a matter of law. If the agreement is incapable of giving rise to a tenancy for some old and technical rule of property law, I do not see why, as a matter of principle, that should render the agreement invalid as a matter of contract. The fact that the parties may have thought they were creating a tenancy is no reason for not holding they have agreed a contractual licence, any more than in Street and Mountford. The fact that the parties clearly intended to create a licence precluded the court from holding that they had, as a matter of law, created a tenancy. And he goes on to consider a case of Milmo and Carreras about whether a sublease for a term concurrent with the lease amounted to an assignment.
How does paragraph 63 fit with your submission that the court sort of identifies the best fit to give expression to the parties' agreement?
Well,
because if they had thought they were creating a tenancy, you would think that was the best fit.
Well, what happened in Street and Mountford is that the agreement wasn't void. There was no invalidity in Street and Mountford. It was the old spades and forks problem in Street and Mountford. The parties in Street and Mountford had in fact created a term certain at a rent for a term.
So whatever they called it, it was a tenancy.
Didn't matter.
Yes.
Label substance doesn't matter. And just picking up on a point that my Lord the Master of the Rolls made this morning, it is of course the case that the courts can occasionally trim off terms, and what remains might then amount to a tenancy. So just to give an example, that there was a line of cases in which people sought to evade the Rent Acts by putting in entirely artificial clauses in agreements. You've got to move out between 2 p.m. and 4 p.m. every other day, that sort of thing, which were never intended to be enforced in the shams, and they could be blue penciled out. But the characterisation of what was then left over was a matter for the court to determine, not for the parties to label. And so the simple point that I simply make is...
What's the case about 2 p.m. to 4 p.m.?
I think it's Hussein and Mailman. I was trying to look it up over the shorter German, but I couldn't quite lay my hands on it. But I think it's Hussein and Mailman.
Hussein and Mailman.
Mehlman. I had to scour the memory banks for that, so forgive me if that's wrong. I'll check that afterwards. Turning the page, which you have been taken to, but I'd just like to remind the court of, the rival arguments are then set out between 64 and 65, and then at 66, if the agreement cannot give rise to a tenancy, then, if it is not a contractual licence, the only right that Ms. Beresford could claim would be that of a periodic tenant on the terms of the written agreement, insofar as they are consistent with a periodic tenancy, because she has been in possession purportedly under the agreement paying a weekly rent to Mexfield. It is worth briefly considering why she would be a periodic tenant on this basis, not least because it is Mexfield's contention that this is the right analysis. So this was indeed the analysis that Mexfield were advancing in the Supreme Court. And Lord Neuberger says...
So you say it's ratio, do you?
It's certainly part of the reasoning of the court, in my respectful submission. It's a contention that Mexfield, the reporter, is putting forward. And Lord Neuberger says it would be because the law will infer a contract on those terms from the actions of the parties, namely the terms they purported to agree in the agreement, and Miss Beresford's enjoyment of possession and payment of rent. And this is the important bit in my respectful submission, that the ultimate basis for inferring a tenancy and its terms is the same as the basis for inferring any contract and its terms between two parties, namely what a reasonable observer, knowing what they have communicated to each other, considers that they are likely to have intended. Given that no question of statutory protection could arise, it seems to me far less likely that the parties would have intended a weekly tenancy determinable at any time on 1 month's notice than a licence which could be determined pursuant to clauses 5 and 6. And that's why I say, my lords and lady, that this isn't a common law default rule of law. This is the modern approach that we see in Lord Neuberger's judgment, which is a question of seeing what the parties are likely to have intended. And in this case, we have very clear words in clause 2.1 and a carefully drafted agreement, which in my submission is not redolent of a tenancy, is otherwise a perfectly valid contract, which is neither illegal nor contrary to public policy, nor unenforceable for any other reason. And the best fit with what the parties intended objectively is to give effect to this agreement upon its terms. It may well be that there are instances where a lease is wholly void because it wants formality or because there is some other external reason why it's void, and the only available analysis, the only best fit, is a periodic tenancy. And indeed, many of the cases are of that exact situation, for example, non-compliance with the statute of frauds. But
what
beyond
I don't understand, if I may say so, is if you have the elements which Lord Templeman says leads you to infer a periodic tenancy, and you have a document which is a void tenancy, not a tenancy at all, then what are the parameters that the court uses to decide between the one or the other? And it seems to me at first sight that those are not clear and actually in conflict. It's all very well to say what's the best fit, but the best fit doesn't work if you have clear inconsistency. So, I mean, actually, in both Maxfield and in Prudential, there was clear inconsistency. I mean, do the textbooks say that Prudential is still good law?
The textbooks say Prudential is still good law, although on this specific point, for example, the passages which my learned friend has handed up, Prudential is not mentioned in any of them. It's not referred to in Woodfall in relation to the default common law rule of entering under a void lease at 5005.
So what's it still good law to say?
It's not been overruled, so it is good law in that sense.
It's not a...
It's not been overruled, so Prudential remains good law. But in my submission, it has to be understood in the way it has later been interpreted in Maxfield, in Lord Newburger's judgment, and indeed applied in a later case by Mr. Justice Hilliard, which is the Walker decision, which you'll find in the second bundle of authorities. Tab 18. This was not quite a rerun, but it was a sort of Maxfield Part 2. And what was decided in that case was that it was not possible to convert an uncertain tenancy into a 90-year tenancy, because that was contrary to what the parties intended. And Mr. Justice Hilliard gives a certain amount of anxious consideration to the question that's vexing this court in relation to the third argument. And he does so at page 225, paragraphs 84 and following. He notes that there is unanimity between the Supreme Court, as there was in Maxfield, that the right answer lay in the question of contract. I'm sorry, he says in the first instance that he thought at first blush what he was dealing with was a matter that could not be capable of being resolved by a contrary intention of the parties. In other words, that there was a rule of effectively
Sorry, where are you?
law at 86 at the bottom of 225.
Thank you.
And at 87, he then says that ultimately I've eventually concluded that there is a solution that does give effect to the intention of the parties. The solution in that case revolves around the difference between, on the one hand, accepting, as plainly one must, that the rule can be applied in circumstances where parties had no inkling or intention that it would apply, and on the other hand, accepting that its application is mandatory even where the parties' intentions were contrary and their agreement contains fundamental terms that simply cannot be carried over into a 90-year lease. But the passage that is most important is at 94.
I find that very difficult to understand, paragraph 87.
So what he's essentially saying is that the rule of conversion into a 90-year tenancy yields to the intentions of the parties. And at 94, he goes on to say, I think it is permissible to take into account the following additional matters in support of his approach, that is to say the intention-based approach. That all members of the Supreme Court appear to have been receptive to the analysis that if an agreement could not take effect as a tenancy for want of certainty of term, it could nonetheless subsist as a contractual licence, taking effect between all the parties according to its terms, see especially per Lord Mance. And two, all members of the Supreme Court recognise that unless the insistence on certainty of term is ultimately abandoned, some such solution must be devised, is in the case of corporate tenants. And all members of the Supreme Court concur that the contractual licence would have the same effect as between the parties. And fourthly, Lord Hope was puzzled by the solution of a contractual licence was not both obvious and sensible. And fifthly, that the solution of a contractual licence may not have been contemplated when the rule was devised, and not a single authority post 1925 was found in support of the inexorable application of this aspect of the rule, and it seems odder still that pre-1925 authority should be treated as mandating the negation of an entirely workable agreement and its replacement with a different relationship, which is not only not what they intended, but is quite contrary to their intention and the structure of their underlying contract. In short, I consider that the solution of a contractual licence is not precluded by the Maxfield case and is open to this court and should be adopted. Now, I align myself with Mr. Justice Hilliard to say, in saying that the obvious solution to giving effect to the parties' intentions is simply to allow the agreement to proceed on its terms as agreed in the form of a contractual licence, and that the reconciliation between Prudential and Maxfield lies in understanding that there is no automatic rule that inexorably collapses an agreement that is otherwise not a valid lease into a periodic tenancy, but that it is a question of looking at the individual circumstances, and that, as we've described, the modern approach set out in Maxfield and we say Walker.
Well, was there in his case a exclusive possession and the payment of rent?
My understanding is there was. I'd need to double check, but my understanding is there was, although I see my learned friend shake his head.
Shake or nod?
No, my permanent state of perplexity. Sorry, my lord.
If I may, I might just ask my learned junior to check that. But that is essentially the position that I say you reach in relation to Prudential and Maxfield. There is no reason, as the Supreme Court noted in Maxfield, for this court to simply ignore the terms of a contract or strip parts of it away to achieve a result which does not reflect that which the parties intended.
Does it not depend on where you start from? If you start from the parties intend to create a lease, it becomes rather circular. You then have to identify why it's not a valid lease, it's a void lease, and why do you then go to a contractual license if the intention originally was to create a lease?
I think there are two potential answers to that apply in this case. The first answer is that, of course, if one looks at the agreement on its own terms, it's a license that it's created for want of a term certain. But secondly, one then also has to look at what the supposed lease might look like on my learned friend's case, which I haven't addressed you on yet, but which we need to come to. You know, what is the periodicity? How do you calculate it? How does it all fit together?
I understand that, but in your first point, you say because it's an uncertain term. But for that, you're saying it would be a lease?
If there is no term uncertain, then I am stuck with the findings of the judge below, which I haven't appealed, which is that there is exclusive possession, which he found on appeal against me, and there is a rental payment.
So that is the only element which makes it a void lease?
Correct. What the parties have created, looking at the agreement on its face, is something that is incapable of being a lease solely for the reason that there is no term certain.
And is it fair to describe it as a void lease?
It's fair to describe it as void as a lease or incapable of being a lease. It cannot be a lease on its own terms. Whether that then leads to the whole agreement being void as a matter of contract, that's then the issue that I say is left open in Maxfield. But there is a degree of consideration of that in Maxfield itself, my lord, which is worth looking at.
Before you do that, I just want to be clear about what you're saying. So you're saying on the basis of the agreement and on the basis of the judge's findings, it had two of the three elements necessary to be a lease.
It did.
And therefore you are accepting, are you, that it was a lease, or would be a lease, if there were a term certain?
Yes, I have to accept that.
You have to accept that. And so, have you not squeezed out the potential for it to be a license, which is what the judge found in any event?
No.
Okay. Where's the space for that?
It is possible for a license to confer a right to exclusive possession.
Exactly. That's what I was wondering about, what you were saying, about whether you were accepting, because of that, you were out of licensed territory. And I
I'm
was
not.
a little bit surprised by that.
No, I'm not.
Okay.
I wish I were in front of you with another argument that there's also no exclusive possession. I'm not in front of you with that argument. It's not available to me.
No, but the fact that there is exclusive possession and rent, you're saying, does not necessarily mean that there is a lease.
No, and again,
I'm sorry, I just wanted to clarify that because I wasn't
that's
certain that that's what you were saying.
That's absolutely clear. It's clear from, for example, Street and Mountford itself, where Lord Templeman accepted that there might be some relationships where there was exclusive possession, where there would nonetheless not be a landlord and tenant relationship, acts of generosity, familial relationships, a vendor letting his purchase in early, and so on. And this court has also recognised, just off the top of my head, for example, Manchester Airport and Dutton, that a contractual licensee, in that case a developer of the Manchester Airport site, might be able to get squatters off their land and have possession for the purposes of that. So it is a hallmark of a lease that there is exclusive possession. I can't get beyond that, but it does not follow that anything that has exclusive possession can only be a lease.
Yes.
And just to address that point, that is something that was noted in Mexfield itself. So Lord Clark explains, this is page 203, he observes that the question of construction, as we were discussing this morning at 107, is just a normal matter of construction. And at 109, in this regard, he says, I agree with the views of Lord Newburger expressed in paragraphs 57 to 64, which are the ones we've just looked at. Miss Beresford has been living in the property for a considerable time, and except for a short period referred to by Lord Newburger at paragraph 7, has been paying rent at the rate provided for in the contract. It would, to my mind, be bizarre for the law to imply or infer a contract between the parties to the effect that there is a periodic tenancy between them at the contractual rate. That would mean that Mexfield can bring to the contract to an end by giving 1 month's notice to quit. I see no basis for such an inference or implication. It would be contrary to the basis it would be contrary to the express terms of the agreement, and it refers to clause 6.
Yeah, but that is all. That reasoning is precisely applicable to prudential.
Yeah, yes.
So why doesn't the head note say prudential overruled?
My lord, I don't know, although all I can say is Lord Newburger was well aware of prudential because we see it sitting in the middle of his discussion of this precise problem, and his solution to it is to say, effectively at the end, that it comes down to an assessment of what the parties' intentions might be and might have been. In this case...
How can the parties be taken to have intended something that is directly contrary to what they said?
Well, in this case, all I can say in this case, the parties' intentions are clear from clause 2.1. That is what they intended to achieve.
Yes.
What my learned friend's submission amounts to is saying that it is impossible as a matter of general universal policy under the English common law freely to negotiate a contractual license, because that must always have a blue pencil put through it, and it must be converted into a periodic tenancy if there is a cyclical payment and exclusive possession. That is to put the cart before the horse, I say. One looks at the terms of the agreement, one construes what the parties wanted to achieve and tries to achieve it, and in this case, the only way in which the parties' intentions can be achieved is by giving effect to the agreement as a contractual license. In prudential, when one looked at the terms of the agreement, the only way to give effect to that agreement would either have been as a contractual license without the ability to bind successors, or to blue pencil the restriction. And that is the battle that was placed before the House of Lords, and nobody can tell.
Why couldn't you give effect to the terms by way of a license?
Well, one suspects that in that case that argument wasn't pursued because it was a fight between successors in title. So it wasn't the original landlord who was intending the road widening who was a party. So one presumes that the decision was made by the landlord in that case that it was essential that there should be a proprietary interest, so that successors and title were able to enforce its terms. And that is then how the appeal was put, my lord. One tries to understand why the case was put the way it was, but that in that case it suited the landlord to argue for a periodic tenancy due to the circumstances of that case.
But if you look at Lord Justice Lewison, in the, I don't know, the Avondale Park case, he, you know, who's not unnamed to this area of the law.
No.
And he says at paragraph 35, the judgment held that the sublease had automatically terminated and continued possession and payment of rent gave rise to a tribal issue of periodic tenancy. This is the conventional result of common law, where the tenant enters into a void lease but pays rent calculated by reference to a year. The terms of such periodic tenancy are the same as those of the void lease, except, these are the words, where they are inconsistent with a periodic tenancy. And then he cites, and this is after Maxfield, as Lord Templeman put it, since blah blah, Mr. Holland didn't challenge the judge's view that there was at least a serious issue to be tried as whether periodic tenancy had arisen. I mean, luckily he's on good ground here because he's arguing the same side of it. Well, and then there's a bit about estoppel. Now, is it correct as a matter of law to say that in that situation the terms of the periodic tenancy are the same as those of the void lease, except where they're inconsistent with the periodic tenancy? And if that is correct, then why doesn't it apply to the facts of Maxfield?
Well, it is correct to say that if the right answer is one reaches for a periodic tenancy because property law abhors the vacuum, and it is right to say that the terms of those that tenancy, save insofar as inconsistent, are transferred over. But in Maxfield, as you saw from the passages I took you to, the effect of the periodic tenancy would have been to give Maxfield a right on a month's notice to serve a notice to quit. And that wasn't the bargain the parties had struck. That was not a good fit with what the parties had purported to do.
Well, you could say it would completely change it, because it gave them a right which was extremely a broad right, which otherwise would be extremely limited.
Yeah.
We don't have that here, do we?
Well, what we have here is that we are changing. Well, we're doing two things. And whether we can do it, I still need to address you on the terms of the agreement. But we are changing the essential nature of the agreement from an open-ended license arrangement, spooling out infinitely, unless and until brought to an end by one of the provisions under Clause 2 of the agreement. That agreement was valid as a old code agreement under the old Electronic Communications Code. It was not within the provisions of the Landlord and Tenant Act 1954 if a license. If your lordships and ladyship were now to convert this into a tenancy, then this agreement would always have been a 1954 Act protected tenancy. And if a 1954 Act protected tenancy would, upon the coming into force of the Electronic Communications Code, have been governed by the provisions of the 1954 Act and the rent provisions under it, and not the new code. So that's one difference that it makes. And the second difference that it makes, as we set out in our skeleton argument, is that this, if an annual periodic tenancy, would also not carry with it any renewal rights under the 1954 Act.
But that's not the answer to my Lord's question. My Lord asked you, and it's a question that I'd quite like an answer to, do Maxfield, if they had decided a periodic tenancy, would have given the landlord a broad right terminate instead of the narrow one in clause 6
Yes.
that he had by agreement. But, said my lord, not here, because here there was always a right to terminate on 12 months' notice, and the only difference, going with the grain of the agreement, is that under the periodic tenancy it has to terminate at a particular time.
Yes. Subject to, and I don't differ from my learned friend, subject to the right to vary the common law termination and period. That is a right the parties have that they can do by agreement. That's correct. So I don't dispute that. And your lordship is right to say it isn't the radical difference that one sees in Maxfield. That's also correct. But where there is a difference is the legal characterisation as a periodic tenancy carries with it different statutory consequences from those that would apply were this to be a licence given effect to in accordance with its terms.
Well, I mean, I think you've sold that pass really, because you've accepted that it's a tenancy all bar an indeterminate period. Well,
the question that the court needs to ask itself is there any need to intervene to turn the clause 2.1 clearly agreed term into a periodic tenancy? Or is it perfectly possible simply to give effect to what the parties have agreed clearly and contractually? My submission is that if one is looking at an arrangement which fits most with what the parties clearly intended, Maxfield and its understanding of where one goes on the prudential spectrum leads one to conclude that this should be given effect to on its terms, and the effect of it is a contractual licence.
Well, I mean, I would benefit from being told what test the court is to apply when this situation arises. I mean, it's all very well to say, well, what's the best fit? I mean, that's a very qualitative judgment, which doesn't seem to me to be very well suited to the area in question. I mean, there must be a proper resolution. I mean, Lord Neuberger understood Prudential was there, understood what Prudential said, understood the facts of Prudential,
Yes.
decided not to overrule it. So, we therefore assume that the Supreme Court has accepted, and Lord Justice Lewison definitely has, that Prudential's good law and Maxfield's good law.
Yes.
So you both, it seems to me, have slightly missed some of the tricks here by not putting in your skeleton arguments how it is that the court is supposed to reconcile those two cases. Because, for my part at least, the way in which we reconcile those two cases is likely to determine the outcome of the appeal.
Yes. Yes. Well, my lord, the problem is that confronted with a term uncertain situation, the court has a binary choice. Uphold it as a licence on its own terms, or convert it into a periodic tenancy shorn of all of those terms which are inconsistent with the nature of a periodic tenancy. That is the binary choice that the court has to make. In Prudential, the House of Lords plainly thought, not least because of the way the appeal was being advanced in front of it, that it was having to choose between either an invalid tenancy or a periodic tenancy, and that a contractual licence wasn't argued, but B, wouldn't have resolved the problem that it was dealing with, because it was dealing with parties who had successors in title, one party's successors in title, and it was dealing with an interest which obviously the parties had intended clearly to be a tenancy. In Maxfield, the binary choice was either to uphold this, well, in Maxfield there were three choices, one of which presented itself, and the choice that the Supreme Court made in that case was the conversion into the 90-year term. Had that not been available to it, the Supreme Court would have had a binary choice between converting Ms. Beresford's agreement on its own terms into a contractual licence, or rendering it as a periodic tenancy, And the latter did not recommend itself in Maxfield, as I say, because of the immediate vulnerability of Mrs. Beresford if that had been done. And that seemed to be the only reason why the Supreme Court didn't want to take that route. In this case, you don't have the same starkness as Maxfield between the two binaries. I accept that. But what Maxfield tells us is that in the first instance, we should try to give effect to the contractual arrangements between the parties on the terms that have been agreed. And there is nothing contrary to public policy in the parties agreeing an agreement in the form of this particular agreement. There is no reason for the court to go behind it.
While it's in my mind, at some point, can you point to the paragraphs in the judgment in which the judge deals with the intention of the parties? And one of the reasons I say that is, speaking for myself, I might start at a different position, in that I might look at this agreement and say, is it a lease, but for, or is it a license? But the way the submissions have developed today, picking up what my lady said, it seems that both parties are starting from the position would be a lease, but for.
Yes.
Right.
That is simply the position.
Okay.
Now,
But you see, you say the choice is not so stark, but we should first try to give effect to the parties' intentions. What I don't understand is why a periodic tenancy terminable on 12 months' notice, not less than 12 months' notice, after the 10-year period, doesn't give effect to the parties' intentions.
well, for that I need to take you then to the slightly more granular terms of the agreement, because what we've had today is a discussion about there being a periodic tenancy, but not really any explanation of what the periodicity of that tenancy is to be and how it's all meant to fit together. I won't go through the cases that you've heard already, save to observe that, as in the Leeds case, it is accepted by me, and I don't dispute, that it's possible to have an initial fixed term followed by a periodic relationship. That is legally possible. That is what Leeds says. But that has to work and work together and function. How does it function, or how can it function in this agreement? So what my learned friends, my learned friend's secondary argument.
Well, I mean, to cut through this, I'm perfectly willing to accept that the actual provisions here, with funny quarter days and funny start dates, which are completely unimaginably stupid from a landlord and tenant lawyer's point of view, doesn't fit in with a periodic tenancy.
Yes.
And so you can use those eccentricities, if I can call them that, to support the proposition that you cannot give effect to the parties' precise intentions. But the point I was putting to you really was the more general one, which is that, which still feeds off my lord's point, which is that, actually, the reason in Maxfield for doing what they did was that it was flatly in conflict with the termination provisions, and it would have therefore been doing something that common lawyers hate to do, which is to drive occasion horses through what the parties agreed. It's not quite as bad as that here, accepting it has certain elements of badness. It's not quite as bad.
No, I have to accept it isn't quite as bad. But that doesn't get one past, in my respectful submission, the question of why not, as it were, one asks, give effect to the contract on its own terms.
I suppose you really come down to your point, which you started with, which we slightly poo-pooed initially, which is that you've got to look for the best fit.
And that, and B, I cling to the observations of the rest of the justices in Maxfield. So, just for your note.
Yeah, we know where they are.
Yeah. And it is something that troubled, in particular, I believe, Lord Mance greatly.
103.
That starting at 99.
Right.
Where he records the submission made for Maxfield that the agreement has to take effect as a tenancy, but for a wholly different kind to any which the parties intended, and that it would be terminable at any
Sorry,
time.
where's that?
This is paragraph 99. He then records that that is not an attractive outcome from his point of view, the submission my learned friend is making. And he then indicates that the standard position is that there are 3 hallmarks of a lease, as in Street and Mountford. He then records, as you are ahead of me, my lord, but at 102, on the hypothesis I'm presently considering, those 3 characteristics, that say term, rent, and exclusive possession, were not all present. The basis for asserting that there was a contractual tenancy therefore falls away, but the contract was valid as such. There is no reason not to give it effect according to its terms. As a matter of legal characterisation, because it was not a tenancy, it can only involve a licence. Its terms precluding the giving by Maxfield of notice to terminate, except in circumstances falling within clause 6 of the agreement. So the first point to make is that it's precisely the situation that we've got that's under consideration, where one of the 3 hallmarks is missing, and one of those 3 hallmarks deprives it of the status of a tenancy. And Lord Mance notes that to force the contract into the category of tenancy by rewriting its essential terms to provide for a periodic monthly tenancy terminable on a month's notice would be to substitute for the agreement that the parties have made a wholly different contract. It would be to treat the first 2 of the 3 characteristics of a tenancy mentioned above as sufficient by themselves, and as displacing any need to satisfy the third. It would be to insist on terminology such as the agreement's references to letting and taking possession from month to month in this tenancy over substance. And so the reason why I draw that to your lordship's attention is that one has to be careful not to jump to the conclusion that if there is a cyclical payment that's being made and exclusive possession, that means that one has to inexorably conclude that there is a tenancy and supply the missing third characteristic, the term. And as to my lord the Master of the Rolls point, that there may be an issue about a different point of distinction between Maxfield and this case, because in Maxfield the effect of conversion into a periodic tenancy is radically different. It's worth reminding oneself that Lord Neuberger identified the technical, what he called for technical reasons, the tenancy not being able to fit into the agreement not being able to fit into the category of lease. So it's certainly not a part of Lord Neuberger's reasoning that, or rather Lord Neuberger's starting point is that a technical deficiency in rendering something incapable of being a tenancy is enough to give effect to it as a contract. So my lord, it is
actually Lord Dyson doesn't support the other judges. Lord Dyson says, I would however go so far as to say that like Lord Neuberger, I'm strongly attracted by the submission, that if by reason of the uncertainty argument the agreement did not create a tenancy, then it was enforceable as a contract according to its terms, like any other contract. So he's strongly attracted to that, but he hasn't gone for it
yet. But my lord, yes. But this is the point of the central point in my submissions, which is that what my learned friends are inviting you to do is to supply the third missing element when the parties to this agreement have agreed that there shouldn't be the third missing element, that they have entered into a contract, as you observed this morning, in the clearest terms under clause 2.1. That is what they have agreed.
That's what Lord Templeman did.
But again, my lord, the only, as you've heard what I've had to say about how one can reconcile them, there is, I am unaware of any...
Reconcile them on the basis that basically this wasn't argued in front of Templeman.
No, and that neither party evidently wanted that to be the solution because it didn't suit either party's intentions on the facts of that particular case. On this case, this agreement is perfectly, has been a perfectly workable agreement at the point of grant on the terms on which it was granted. And again, if your lordship has all those points about the dates, the short point I was simply going to make was
better fit.
Yeah, they don't fit. They don't fit in a number of ways, of course, because as you'd have seen, the tariff is backdated to before the term starting.
I've never seen such a nightmare. I don't know what they were doing. I mean, where did they get those quarter days from?
Welcome to my world, my lord.
Okay, you see a lot of it.
I see a lot of them.
Okay.
But yes, my lord, that's really how I have to tackle Mexfield. I have not, apart from the Walker decision, I've not found anything else that tries to grapple with this particular question.
And I should add, of course, that Lord Newburger was counsel in Prudential.
He was losing counsel in Prudential.
That is.
So it would have been his opportunity as well.
That is very interesting.
I was going to point that out.
Yes. So, I mean, I'm not trying to cut you off.
No.
But you basically say to completely ignore anyway 3 very clear judgments in the Supreme Court, those judgments being plainly aware of Prudential, and follow Prudential and ignore those, even if they're not strictly ratio, would be adventurous even for the Master of the Rolls.
Well, my lord, what I would say is that Mexfield plainly undertakes a reappraisal of how the courts should approach these sorts of agreements. It doesn't say Prudential is wrong because it doesn't have to, because it doesn't have to commit itself to saying that the answer in Prudential is the inexorable one whenever one gets an agreement that's intended to be a license. Sometimes a license is just a license and not a periodic tenancy in disguise.
I mean, Okay. Well, I was just contemplating that we didn't need quite such extensive submissions, bearing in mind that we've only got 1 hour left for this hearing. We didn't need quite such extensive submissions on points 1 and 2 raised by the appellant, but no doubt you'll want to make any points you think we haven't got.
If I can just, I can be quite brief on those. I just wish.
Don't forget about intentions, because you referred to intentions again. I would like to be reminded where in the judgment your submissions on why the document, the agreement, that you can conclude from the agreement that the parties intended a license, not a lease. When I thought your submission was that it would be a lease, but for. So just bear that in mind. I'm not asking for an answer now, but just intentions.
Yes. What I just wanted to make sure the court had in mind in relation to ground 1 and ground 2, very briefly, is that the court should be aware of one of the foundational decisions which you haven't been taken to, which is the Lace and Chandler decision. And the only thing I'd like to draw your attention to is how the test for certainty of term is to operate. So this is going right back to what would have been the beginning of my submissions to frame what came later. And it's tab 4.
Ladies and gentlemen, is the duration of the war case.
That's for as long as the war. Essentially what happened in that case was the rent book indicated that the premises let were to be furnished for the duration. And the way that was interpreted was that it was for the duration, as you say, my lady, of the war. What I would say is important in understanding the test, because it's carried over into Prudential and then into Mexfield, is what Lord Green says at page 23, about a third of the way down. He says, normally there could be no question that this was...
Sorry, hold on.
Sorry.
Page
23.
Thank you.
This is Lord Green.
This is Lord Green. and this is normally there could be no question that this was an ordinary weekly tenancy duly determinable by a week's notice, but the parties in the rent book agreed to a term which appears to, there expressed by the words furnished for the duration, which must mean the duration of the war. The question immediately arises whether a tenancy for the duration of the war creates a good leasehold interest. In my opinion, it does not. The term created by a leasehold tenancy agreement must be expressed either with certainty and specifically, or by reference to something which can, at the time when the lease takes effect, and that's important, be looked at so as to a certain ascertainment of what the term is meant to be. In the present case, when the tenancy agreement took effect, the term was completely uncertain. It was impossible to say how long the tenancy would last. The fact that at some future time it will be rendered certain is sufficient. He then rejects the submission that the fact that the war would end at some point in the future and could therefore render the term certain was good enough. In my opinion, the argument is not to be sustained. And he then quotes from FOA, which is an old rival to Woodfall that Woodfall killed off, in which the author writes, and Lord Green accepts, that the habendum in a lease must point out the period during which the enjoyment of the premises is to be had, so that the duration as well as the commencement of the term must be stated. The certainty of a lease as to its continuance must be ascertainable either by express limitation of the parties at the time the lease is made, or by reference to some other collateral act, which may, with equal certainty, measure continuance of it, otherwise it is void. If the term is to be fixed by reference to some collateral matter, such matter must either be itself certain, so for example the interest that the landlord holds, or capable before the lease takes effect of being rendered so. The important words to observe in the last phrase are the words before the lease takes effect, and he concludes, in the present case, in my opinion, this agreement cannot take effect as a good tenancy for the duration of the war. So the test that your lordships and your ladyship are required to apply takes place just before the lease is entered into, and you ask yourself whether the agreement that you have in your hand has a certain terminus. And that terminus is either fixed by reference to a period of years, or it can be fixed by reference to an event if there is a period of years serving as a long stop, or it can be by reference to a periodic tenancy which renews itself in accordance cyclically with the terms of the period on which it is granted. What is not sufficient is an event which is not knowable at the date at which the lease is entered into. In Lace and Chandler, that event obviously operated independently of the landlord and tenant. It was the ending of the war. In Prudential, it was something that was within the volition of one of the parties, the desire to widen the road. In Ashburn Anstalt, it was also something that was in the volition of the parties. The need to resume occupation possession in order to carry out a development. And I should say to my Lord the Master of the Rolls, you will also see that in this case, at 371, just so that you're aware, bearing on the debate we've had earlier on, that lastly Mr. Sturge argued that the agreement could be construed as an agreement to grant a licence.
Where is that?
That's at the bottom of page 24.
Ah, yes, at the very bottom. Thank you.
Yep. In my opinion, it is impossible to construe it in that sense. The intention was to create a tenancy and nothing else. The law says that it is bad as a tenancy. The court is not then justified in treating the contract as something different from what the parties intended and regarding it merely as a contract for the granting of a licence. That would be setting up a new bargain which neither of the parties ever intended to enter into. The relationship between the parties must be ascertained on the footing that the tenant was in occupation of paying rent. Accordingly, it must be the relationship of weekly tenant and landlord and nothing else. So the key there is then again, what were the parties seeking ineptly to do? And what the parties there were seeking ineptly to do was to create a relationship of landlord and tenant. What's the best fit? Well, in that case, my submission, that explains what Lord Green says, that the best fit there is the creation of the weekly tenancy. But that's the importance of the test. And if we then track the way that test has been carried through, you'll see from Lord Brown Wilkinson's judgment in the Prudential case, tab 13, page 149, more or less level with letter H at the bottom.
Sorry, which page?
This is page 149 in the bundle of authorities.
Yeah.
And it's the text next to letter H. The duration of a term of years has to be ascertainable from the outset. And that is carried through again by Lord Neuberger into Mexfield at 185, which is his paragraph 33. Following the decision of the House of Lords in the Prudential case, there it is again, the law appeared clear in its effect, intellectually coherent in its analysis, and in part unsatisfactory in its practical consequences. The position appears to have been as follows. And he says, an agreement for a term whose maximum duration can be identified from the inception can give rise to a valid tenancy. The agreement of which gives rise to a periodic arrangement determinable by either party can give rise to a valid tenancy. And then he goes on to consider the Feta case and the other instance. But the reason why that's important is because once one appreciates all of that, one can see why my learned friend's argument, which is based entirely on paragraph 93 of Baroness Hale's judgment on the so-called invalidating conditions, can't be right. It is not right, I submit, that any agreement can be a lease provided it doesn't have one of the two invalidating features identified by Baroness Hale at paragraph 93. And it's also not right that one can, anything that slides through those two requirements should be treated as a lease. What we can see from paragraph 33 in Lord Neuberger's judgment is that one has to, in the first place, be able to point to something that's a lease on conventional principles, either a fixed term tenancy or a periodic tenancy, or the Leeds type amalgam of the two. So the first argument fails because, in my submission, because it's not right that if there are no invalidating features, it must be a tenancy, and we don't have to wonder what sort of tenancy it is. And that, I say, follows from the words of Baroness Hale herself, because she explains, after her curious comment, that there is a rule against uncertainty which applies both to single terms of uncertain duration and to periodic tenancies, with a curb on the power of either party to serve a notice to quit. So before one even gets to the invalidating conditions become a consideration only once one has established either that there is a term uncertain, which I say clause 2.1 is in any event, so that there is an invalidating feature here, or if one has established that there is a periodic tenancy with an impermissible uncertain feta. So it's not enough to say, oh, there's an impermissible uncertain feta, or there is an ability to terminate and therefore there is no mischief. One has to still be able to show what the underlying nature of the leasehold interest is. So the argument based on paragraph 93 involves ignoring what I say is an integral part of Baroness Hale's reasoning in that, which is the which is her statement to the effect that one first of all has to ask oneself whether there is a conventional leasehold interest. In relation to, so that's what I say about the first argument. In relation to the second argument, I think you have my points already. It is not, I submit, a promising start to the argument that there are three different versions of what this could conceivably be that you are invited to choose between in relation to argument 2. It simply makes the point that this is perhaps an attempt to shoehorn something that isn't a lease into a category into which it doesn't fit, the Lord Clerk objection. And your Lordship has, my Lord the Master of the Rolls has already made the point about the misalignment of the various interests. In relation to what is said by the judge below, I've just slightly taken that on the hoof because I haven't actually drawn out in my notes where the learned judge deals with the question. He at paragraph 310 in his judgment, this is addressing your point, my lord, on his intention. He goes through Prudential and Mexfield, and he then says, applying the reasoning of their lordships in Mexfield, which I've quoted above, I cannot see that it is possible to imply a periodic tenancy in the present case, brought about by Orange's possession of the Sandbach site and the payment of the equivalent of an annual rent. Orange's possession of the Sandbach site was clearly intended by the parties to be on the terms of the 1997 agreement, including the termination provisions in clause 2.1. If, as I have decided, those termination provisions were incompatible with a periodic tenancy, it seems to me on the basis of the relevant reasoning in Mexfield that it is not possible to imply a periodic tenancy in place of the void lease constituted by the 1997 agreement. To adopt the language of Lord Clarke, such a result would be contrary to the express terms of the relevant contract. Instead, it seems to me that I am correct in his argument that on the hypothesis that the 1997 agreement was incapable of taking effect as a lease because it was uncertain the position defaults to one where the 1997 agreement took effect as a license. Notwithstanding that on this hypothesis, the 1997 agreement did grant exclusive possession of the Sandbach site to Orange at the equivalent of an annual rent. So that's where I'm stuck in terms of my submissions to you, my lord, with the finding, which I haven't appealed to you, that there is exclusive possession here, and that the judge has found that there is an equivalent, there would be an equivalent of an annual rent. But that is also where the learned judge takes the view that, or expresses that in his judgment, that that it would not be compatible with clause 2.1 for there to be a periodic tenancy, because that isn't what was intended, and that the best thing for him to do is to give effect to the agreement as between the parties. And he then goes on to look at the term issue on the hypothesis that the 1997 agreement took effect as a void lease only by reason of the absence of a term certain. Again, I'm stuck with that. It does not seem to me that an implied periodic tenancy would have come into existence in relation to the Sandbach site on the same terms as the 1997 agreement. Instead, it seems to me that the position defaults to the result contended for by Mr. Radley Gardner, namely that it took effect as a licence with no implied periodic tenancy. On the basis of my analysis, the term issue, I conclude the judge was wrong to decide that it was entered into for a term certain. I've also decided that the position cannot be retrieved by the implication of an annual periodic tenancy, and for the reasons I've set out, the absence of a term certain meant it took effect as a licence. So, my lord, I don't know if that answers your question as to where the judge deals with this issue.
Just a matter of interest, the First Tier Tribunal dealt with this in 2 paragraphs.
Yes.
I mean, were all the same arguments deployed in front of, is it a him?
Yes, Judge Jackson, I think it was. Yeah, yes, they were, but it's fair to say that the time allocations on these cases are fairly tight.
Right, yes.
And as you can probably tell from the length of this judgment, there was a lot of material that this judge had to decide, and I think it was a one-day appeal. And I think I might be right in saying that the issue that we're troubling you with took up perhaps 45 minutes towards the end of that day. There being quite a lot of time.
This is from a one-day appeal?
Yes.
Judgment?
I think it's a one-day appeal. Yes, this judgment was from a one-day appeal, 24th of May 2024.
Right.
The judge makes a comment about
A wry observation.
Yes.
My lord, there's a lot of this. There are a lot of these cases, and those of us who deal with not necessarily this precise issue, but those of us who deal with them, of which four of counsel who do quite a lot of it are in front of you now. It's high volume litigation.
Yeah.
Not necessarily high value litigation, but high volume litigation. So there's a lot of issues like this to be got through. So that's how the judge on the first appeal dealt with that issue. And again, he was taken obviously by my learned friend to Prudential, and then taken by me to both of us to Mexfield, and concluded, as I say, he says at paragraph 310 follows, that he thought the best fit was the licence and that the periodic tenancy didn't accommodate. the arrangement between the parties. There was no reason, in his view, to strike a blue pencil through clause 2.1. It just meant that they'd agreed a spade and not a fork, to use Lord Templeman's analogy from Street and Mountford, and they meant to create a spade. So, my Lord, I've gone at a clip through argument 1 and 2, but unless I can assist you further on either of those, or in any way on either of those, it just seems to me important that the court has in its mind how the test is supposed to work under Lace and Chandler, and the specific point is that it should be predictable from the outset when our temporal relationship comes to an end. And the fudge, if it be a fudge for the periodic tenancy, is that it's the cyclical, perpetually renewing nature of that agreement, unless one of the parties brings it to an end, that is said to furnish the certainty. But what you can't get rid of is the need to establish a certain increment of time that is repeating. That has to be
Do
something.
you want to say anything about Mr. Holland's submission that the adverse ramifications of deciding against him are too terrible to contemplate?
Well, I shall contemplate them. There is a safeguard here, which is the safeguard that I indicated before on Hussein and Mailman. If the parties have agreed something that's a sham, the court is astute to identify that and strip it away. If what the parties have agreed is not a sham, then the parties mean what they say. And if the parties have agreed for commercial reasons to enter into a particular kind of agreement that does not attract statutory security of tenure under the Landlord and Tenant Act 1984 because not a tenancy, in my respectful submission, following on from what's said in Mexfield, the party should be free as a matter of basic freedom of contract and freedom of property arrangement.
To agree what's lawful.
To agree what's what?
To agree what's lawful.
To agree what's lawful. And there's nothing unlawful about the agreement that's in front of you. It just does not fit the categories necessary to fall into the 1954 Act. So that's the first point.
So you say it's not a charter for the unscrupulous.
It's not. It's there to facilitate genuine commercial arrangements. And there are all sorts of reasons, and I'd be speculating, but there are all sorts of reasons why a person might want to enter into an open-ended relationship of this kind. There might be all sorts of commercial reasons why they might wish to do that. There might be all sorts of reasons why they might not wish to enter into a tenancy properly so called.
And this doesn't feed into housing?
It could feed into housing in the sense that if there is a genuine... Oh, sorry, I'm just being... yeah, so the point about terms uncertain is, of course, individuals would have this tenancy for life point, the Mexfield point. That's the one difference between housing and the commercial world, where one is dealing with a corporation. But the other point to make is that if the reason why the parties have entered into something that looks like a license is to purely to evade security of tenure, that is treated under Street and Mountford as a sham, not to be seriously enforced. That is precisely, my lord, what Street and Mountford was designed to do, was to ensure that if one created a four-pronged gardening implement, if one created a fork and not a spade, no matter how much one wished otherwise, if the reason why it resembles a spade, just to push the analogy to near breaking point, is because the parties have artificially enhanced it, the court was able to strip away those artificial enhancements. So there are protections built in. But what the law doesn't do, and what Mexfield tells us the law doesn't do, is prevent parties without any vitiating grounds, without any sham, without any duress, without any other factor that might impugn the nature of the contract. It allows them to freely contract for the use of their land on whatever terms they wish. And one of those ways in which they can do that is to agree an open-ended agreement, which takes the form of a contractual license, in my submission.
And is there any difficulty with that clause right at the end, 9.1 or 10.1, about binding successors entitled?
Well, there's difficulty in the sense that, of course, my learned friend can say, well, this is what they intended, but parties intend all kinds of things in contracts and say all kinds of things in contracts which may or may not be right. And as it transpires, that is just simply not right as a proposition of property law, albeit that, of course, there will be successors in title in the sense that one can, A, assign the benefit of a contractual license, but not the burdens, as we now know. So there'll be a successor in title to that extent, to the contractual license. But secondly, there is no, that isn't an issue really that we've got here on appeal. It may be another one that we would have debated in front of you if I'd have been allowed to appeal the exclusive possession point. But I'm not here with you on that point. That point isn't here.
You tried. Did you try?
That point was not appealed in the end. But so that's why the only issue we've got in front of you is term certain. But of course, I would hitch my wagon to my lord, the Master of the Rolls, and say that clause does not illuminate the question of is the term certain.
Dangerous thing to do, actually.
But those are my submissions on those points. Could I turn around to my learned junior and see if she agrees I've said enough?
Of course you may.
Grateful.
Thank you, Mr. Radley Gardner. Mr. Holland.
My Lord and Lady, on that last point, it may or may not be different, but it would be tolerably clear that one could circumvent certainly the 1954 Act by use of that. So far as it would technically apply in the residential context, albeit then you might be left with a 19-year life tenancy or life tenancy a la Mexfield. Can I deal with my friend's submissions in the order he made them as quickly as possible? So far as my argument 3 is concerned, in my submission the law is as set out by Lord Templeman and reiterated by Lord Justice Lewison in the Mr. Delaney case. Entry into on a void lease, you become a yearly tenancy on the terms of the lease insofar as those terms are not inconsistent with a yearly tenancy. That is the conventional principle and has been so for decades, years, and is still the conventional principle. That's why I cited Miss Delaney to you, because it's a very recent reiteration of that principle in this court. How then does one distinguish between that and what their lordships said in Mexfield? First of all, contrary to what my learned friend said, what they said about it in Mexfield is obiter. If you look at the passage from Lord Neuberger's judgment that he cited, I think he cited from paragraphs 66 onwards, I think. But the point about that is if you look at paragraph 58, the heading of that, it's under the heading Miss Bereford's alternative case in contract. And that was not one that they had to deal with because they found that the lease was uncertain, common law was a life interest, and thereby by section 19496 it's...
But doesn't that really any matter if you say they're wrong? I thought you were probably going to submit that they fit together in some way. The fact that it's obiter.
Yes.
Obiter and right and obiter and wrong are very different things. Yes.
Well, and, I'm just dealing with the point that Master Rose put to me before lunch, that, well, if one is not obiter and the other is, then you have to go with the one that's not, if there is any difference. I mean, perhaps the key is if one looks at, I think it's 103, you look at what Lord Mance said at 103. He says, to force the contract into the category of tenancy by rewriting its essential terms to provide for periodic tenancy terminal on a month's notice would be to substitute for the agreement that the parties have made a wholly different contract. It seems, and that was in the context of saying this is a monthly tenancy, when what the parties clearly intended was a long-term tenancy which could only be terminated by the landlord in very limited circumstances, and was intended effectively to allow Miss Beresford to remain in what had been her own home until she defaulted on her mortgage and there was a mortgage or a bank rescue scheme. I think that's the point. So if you can draw anything, it's that the principle as described by Lord Templeman and Lord Justice Lewison applies, unless to imply a periodic tenancy would be to rewrite the essential terms of what the parties had agreed, or to impose a wholly different contract. Now, if one looks here, we don't get anywhere near that. Let's look and see what the parties actually intended. This is my learned friend, even if one applies to the best fit. The parties intended that there was to be the grant of exclusive possession of this premises in return for a periodic payment of rent. And I do rely upon clause 10 of the agreement, 10.1. The parties intended that there would be successors in title who would be bound. And as the judge held at, I think it's paragraph 231 of his judgment at 102, that is clearly indicative of this being a tenancy agreement.
So where are you?
Sorry, where are we? 227, that's good. Yeah. It's 231 is the one. Returning to the question, I'm considering part
So
decision.
231 of what?
231 of the judgment, the judge's judgment,
Which
at
paragraph?
102 of the core bundle.
Which paragraph?
231.
Yeah.
That's where he specifically deals with the argument in relation to 10.1. And more generally, if you look at what the judge found, if one looks at paragraph 82, which is at page 67, he says, in the present case, if the totality of the rights and obligations in each agreement had the effect of a grant to Orange of exclusive possession of the relevant site for a term at rent, the result would be that each agreement took effect as a lease, even though each agreement was not described as a lease, and notwithstanding each agreement may not have contained the conventional language of a lease.
That was paragraph.
That's paragraph 82, at page 67. If you then go on to paragraph 261, I've already gone through paragraph 231 where he deals with the 10.1 argument. And that's at 108. The outcome of the overall analysis. The result of the differences between my own analysis and the analysis of the judge is, as I've said, that I find myself in respect of disagreeing with the judge. I therefore conclude that the judge was wrong to decide that the 2002 agreement, that's the other agreement with which he was dealing, took effect as a license rather than a lease. It's not a dispute the 2002 agreement was entered into for a term certainly equivalent of rent. On the basis of my analysis, the 2002 agreement was also effective to grant Orange exclusive possession of the Lombard site. In my judgment, the reason I've given the correct conclusion is the 2002 agreement took effect as a lease. The same conclusion does not necessarily follow in the case of the 1997 agreement. The judge was not necessarily wrong in his action to say the 1997 agreement took effect as a license. In the case of the 1997 agreement, notwithstanding my decision on the question of exclusive possession, there remains the term issue to which I now turn. So the judge found, and it's not challenged, that both this agreement granted exclusive possession, and the only reason effectively that it was not a lease was his finding as to the term certain. And he deals with 313, paragraph 313 and 316 are his conclusions, which is page 121. And by way of background, this agreement was entered into under the old code. The old code applied to both licenses and tenancies, and indeed applied in parallel to the 1954 Act. Thus, if you had a tenancy, you could be protected under the 1954 Act as well as under the old code. It's not the case now. So it might be said it was in the occupier's interest to have a 54 Act protected tenancy, because they would then gain the protection of both the 1954 Act and the code. And then ask oneself this: what if one's looking at then applying on argument 3 here, what the parties intended, what is the best fit, or would it rewrite the essential terms of this agreement if you have an agreement which is void only because it's of an uncertain term, but nevertheless the parties enter into, the occupier enters into exclusive occupation of the land, pays a rent assessed annually, a payment assessed annually, has exclusive possession. Why should that not be, should not the principle as set out by Lord Templeman and explained latterly by Lord Justice Lewison apply? Could it be said to be rewriting the essential terms of the bargain, or a wholly different contract, to say that instead of the term that they had envisaged, this was nevertheless a periodic tenancy agreement within the protection of the 54 Act and within the protection of the code? In my submission, no, it couldn't be said that that's the case, and therefore what I've described as the standard position applies. My learned friend then drew your attention to the judgment of Mr. Justice Hilliard in the Southward housing case. With respect, those passages are not relevant. In what Mr. Justice Hilliard was dealing with there was the question of, assume you have a tenancy or a void tenancy, or a tenancy for an indeterminate term granted to an individual. Is the rule that the Supreme Court applied in Mexfield, the common law rule, to the effect that you get an indeterminate term becomes a term for life, is that always applicable? The Supreme Court had left that open, but Mr. Justice Hilliard said, no, it's not always applicable. If on the terms of the tenancy it's not appropriate, then that common law rule applies. And if you go to paragraphs 76 and 77 of that judgment, which is at 223, 75 rather, the question then is whether the second part of the rule, providing for the Carolian transmogrification of an agreement that cannot qualify as a tenancy by reason of the uncertainty of its term into a lease for life and then into a 90-year term, is equally remorseless, even where in a case like this it confounds the plain intention of the parties. The claimant contends the Supreme Court, which did not have to decide the issue, left open the possibility that the general rule might yield to the plain contrary intention of the parties. Defendants naturally are content to abandon their intentions, exceed their expectations by gratefully embracing the remorseless application of what they characterise as a rule. Starting point is to determine whether the claimant is right in its submission that A, the Supreme Court in the Mexfield case left open the question of whether the agreement for an uncertain term was only regarded as creating tenancy of life, if on a fair reading agreement that was what the parties' agreement intended, so that B, it is open to the court to conclude that a lease for life would only arise at common law if on the true construction of the agreements the parties intended it. That's what the Zimbler point. I mean, if you look at its paragraphs 42 and to 44 of Lord Newburger's judgment, that's where he discusses the Zimbler case, because it had been argued in Mexfield by Mexfield that the rule that at common law a tenancy for an indeterminate term to an individual became a tenant, automatically became a tenancy for life, was not automatic. And Lord Newburger, discussing the Zimbler case, said no, it was. But Mr. Justice Hilliard differs from that, or at least says he answers the question that it's not inevitable. But that's the point. So any discussion that Mr. Justice Hilliard has in respect of what the tenancy intends is in a different context altogether and is not relevant to, I would submit to the discussion that which your lordships and your ladyship have to entertain. It also, by parenthesis, means that it's not automatic if a landlord of a individual granted a tenancy, not a tenancy, an agreement granting exclusive possession with such a minimum term. You could argue that that was not a lease and was not transmogrified into a life tenancy, because that's not the intention. That was the argument in the Southwark housing case, but that's by the by. Those agreements which grant exclusive possession but do not constitute leases are strictly limited. They are set out in, or mentioned in Street and Mountford and other cases. And the rule is as set out, if you look at paragraph 101 of Mexfield in the judgment of Lord Mance, he deals with that. If you have exclusive possession for a term at a rent, it's a lease. And there are few exceptions to that, as my friend points out. Family arrangements, serviced accommodation, a vendor or purchaser. But there's a list of them, but none is it. But it's rare that you get that. So that's the point. That if there is exclusive possession at a rent, then if there's a periodic payment of rent, the court will imply a periodic lease. And finally, my learned friend dealt with Lace and Chandler, and his point was you had to look and see whether there was a terminus ad quem in advance. But as Lady Hale points out, and the other in Mexfield, there is a degree of uncertainty as to how exactly that applies in the context of periodic tenancies. The terminus ad quem is uncertain because it continues automatically until terminated. The key, what makes it certain, is the ability to give notice. That's what my submission is on that. And provided there's an unfettered ability on both parties to give notice, that is sufficient certainty. Unless there's any questions, those are my submissions.
No, thank you very much, Mr. Holland. Well, thank you to all counsel, even though we've only heard from two. I hope next time you'll remember the injunction to let your juniors speak, which you've not done today, but maybe we were a bit tight for time. We'll take time to consider our judgments and hand them down in the usual way. When you get them, please remember the embargo. Use them only for the purposes of agreeing an order as to costs and the disposition of the case. And if anything needs to be resolved between you, it will be done in writing.
I'm good. My Lord, can I ask, I think we have attempted to send the relevant documents.
I've got everything except this little bit of paper.
Right. Well, I shall.
So send that, and I've got the Woodfall bits you handed up.
I think it was attached to the same email, but
was it? Okay, but then I haven't.
We'll do it again.
So it may be okay. Thank you very much.
All right.